What's up, everybody? Welcome back into an episode of The Lawyer You Know. And today we're going to be talking about our old friend, former trooper Michael Proctor. We know there's been a lot going on about him, not just in the Karen Reed case, but in a couple other cases. They want all the information that was given to Karen Reed and her team and more. They want to download his cell phones. They want to see if there's any exculpatory evidence, any more of the same that we've seen from Proctor in the past that may apply to their cases. And we also know Michael Proctor has been fighting to get his job back. He has been fighting that termination as wrongful and as not fair compared to other law enforcement officers in similar positions. Well, all of that has now changed. As more information is coming out, more evidence is coming out, more text messages and information from Michael Proctor's phones, and it's affecting everything. We only know but a little bit of it at this point, yet there's a lot to be learned and so much more that I think we are going to see in the future. So we're going to break down everything we have now, answer your questions. We're going to read a court document. We're going to watch a hearing. We're going to read some tweets and, of course, answer your questions. So hit that like button. Make sure all you guys are subscribed to the channel because we're going to get into it. So as promised, we're going to start here with a notice. And it's important for the context of every notice to understand who is filing this notice and why. The who is the prosecutor in this case. I was going to scroll down. Tracy Cusick from the Assistant District Attorney's Office. Okay. And this is filed in the Brian Walshe case. It is going to involve Brian Walshe. It's going to involve Trooper Proctor, former Trooper Proctor, and it's going to involve Miles King, okay? Among others that we don't really know yet. And Ashley D, thank you for sending me a lot of this stuff. But it's really important to understand that this is the prosecutor filing this notice. And why are they filing it? Because a judge ordered them to. A judge ordered them to save certain information, to download certain information, to go through certain information, to look through it and see what's exculpatory, what's not, what's discoverable, what's not. We'll get into how fair that is and what issues we may have with prosecutors being able to do that, even though that's how it works in our criminal justice system. But the prosecutor is the one filing this notice. And we remember that because you would think the prosecutor is on the same side as Michael Proctor. At least many of the prosecutors we've seen in the past have been. Are the tides turning there? Let's take a look. Pursuant to orders in Commonwealth versus Miles King and other cases, the Commonwealth began examining an extraction from a personal cell phone of former Trooper Proctor for information reasonably believed to be discoverable under Massachusetts Criminal Rule P14B2 of criminal procedure. So what I was going to highlight here is they've called him former Trooper Michael Proctor, right? So, and you may say, Peter, duh, he's former Trooper Michael Proctor. Why would they call him anything else? You don't have to do that. You could just say Michael Proctor's cell phone. You could just say we got a download from Michael Proctor's cell phone. You don't say Trooper Proctor, of course, because he's not a trooper, but you definitely don't need to say former trooper. For information reasonably, okay, we already did that. Due to the unexpected volume of files discovered on the cell phone review of the extraction, it is not yet complete. The Commonwealth is attempting to produce information it currently believes, that's going to be important too when we listen to the hearing, to be discoverable by October 24th, 2025, but requires additional time to complete its review of the data extracted from the cell phone. So what is this? What's happening in this first paragraph? The prosecutors are saying, Judge, we're looking at it, former Trooper Michael Proctor's cell phone. We are seeing what's exculpatory potentially. We're seeing what's discoverable. And from our perspective, hold on, somebody said there's a problem with the audio, so I'm going to check with Kelsey to see if the audio is messed up, and hopefully we can fix it if it is. So what the state is doing is they're saying, we have the cell phone, we have the download, and she said the audio is fine, so we're going to keep rolling. And we are looking for information. And we're going to see some of what they say about information a little bit later in the notice. But we need more time. So, Judge, we're complying with your order. We have the download, we have the information, we're looking through it, but we need more time to fully comply with your order. And we will tell you everything that we're going to give over to the defense and everything that we're not going to give over. On June 17th, Norfolk County Superior Court Judge Michael Doolin allowed in part defendant King's motion to preserve and produce former MSP Trooper Proctor personal cell phone, ruling as to the communications, including the content, call durations, times, and numbers involved on former state trooper Michael Proctor. They've called him 3 different names. It was just former trooper, it's former MSP trooper, and now it's former state trooper. Personal cell phone from the date of the charged M of the King matter to the date of the indictments. The Commonwealth shall promptly produce any other data from Proctor's personal cell phone that constitutes investigative material or is favorable to the defense, right? Within the meaning of Massachusetts State Rule of Criminal Procedure 14. That's from the June 17th order. Judge Doolin further ordered that the Commonwealth may move for appropriate protective orders for the court's review prior to producing information, and that defense counsel shall not show or provide the communications produced pursuant to this order to anyone else except that defense counsel may show but not give them to the defendants in this case. So let's take a look at this, because some tweets we're going to read later, some people may take issue with this paragraph. The Commonwealth may move for an appropriate protective order, meaning there's not necessarily a protective order over it right now. And for the court to review the information, and right now, defense counsel in this case, dealing with these cases, defense counsel should not show or provide the communication to anyone else, except they may show, meaning here's what the text messages look like. Let's look at them together, but we're not going to give them to the defendants in these cases. That's King and Walshe is what it seems like. But also seems like there might be more. Maxaw said, haven't caught alive in so long. Ugh, Proctor. Yes, you're back just in time for former trooper Michael Proctor. Jessica, happy belated birthday, Peter. Fun coincidence. I have the same B-day as your dad, and you have the same B-day as my dad. We're practically family. Thank you for all you do. So, Jessica, it's wild how many combinations there are like this with my birthday. I don't know why. Maybe it's everybody's birthday, and I just happen to talk to a lot of people on the internet. So it's coming out more that there are all these connections, but it's wild. And thank you for sharing, because it blows my mind every time I hear it. Upon filing of a motion and amended motion for clarification by Proctor's counsel on August 13th, 2025, Norfolk Superior Court Judge Peter Krupp clarified that the obligation to produce any other data that constitutes investigative materials or is favorable to the defense is not limited to a particular date range. So now it's not just from the alleged crime to the indictments, but now they're going to widen the date range, and that Proctor had a legitimate interest in protecting attorney-client or spousal communications. Judge Krupp ordered that by certain dates, Proctor provide his cell phone to the Commonwealth extract a full digital copy of the cell phone, and then provide a copy to Proctor's counsel for a privilege determination and return the cell phone. Counsel provide a privilege log to the Commonwealth, and the Commonwealth shall search the cell phone extraction with the exception of the communications identified on the privilege log to locate the information authorized by the initial order as clarified herein. So these are all the things that need to be done. And the Commonwealth is basically telling the judge at this point that we've done this. We've got, Proctor has the cell phone. We've downloaded the cell phone. I believe a privilege log has been done, but they haven't finished doing everything else they need to do with the cell phone extraction. Also, if I'm a defense counsel in this case, there are a couple things that make me feel uneasy. The first of which is Proctor's lawyer first gets to go through this cell phone, and they get to say what they believe to be privileged. Now, a privilege log is where you list the documents or the text messages on dates, and you give some type of idea as to why this is privileged. This is Proctor and his lawyer talking about his appeal. Proctor and his lawyer talking about his testimony in the case. Proctor and his lawyer discussing whether he's going to plead the fifth. Whatever it may be, right? You probably don't get that detailed in the privilege log, but the privilege log gives you some kind of an idea as to what this is, because if it's like Proctor talking to his attorney and his wife and Yuri Buchanan all on a group chat, well, I might have a problem with that. I might not think that that's actually a privileged communication. So when it comes down to a privilege log, the defense can argue that certain text messages or things that were pulled from the phone are not actually privileged. And then number two, the second issue I'd have. Prosecutors are really going to tell us what's exculpatory, what's potentially helpful to the defense. What if they don't know all of our defenses? What if they don't know all of our trial strategy? So that gets pretty difficult, right? And that can muddy the waters a little bit. We're going to talk through that as we get to the hearing as well. Ashley said, can we trust them to go through and disclose it appropriately? Here's what I'll say. I am gaining confidence in how this notice was written. And we're going to keep reading. And I think that we've got to leave open the opportunity, and a lot of you are going to totally disagree with me here, but this is how I live my life. We have to leave open the opportunity for assistant district attorneys that work on these cases to build back some trust and to build back some benefit of the doubt. And the way this motion is written, and if more steps are taken into the future, in my opinion, that will give more confidence. But I don't care who the DA is. I'm always going to be a little side-eye about, are we sure? Because we know there's a lot of information in there that's going to be damning for Michael Proctor, which is damning for the prosecutor, which is good for the defense. But let's keep reading. By October 24, 25, the Commonwealth shall produce to defendant King and others a copy of Proctor's privilege log, if any, which is weird. Like, shouldn't they know if Proctor has a privilege log? And all documents required to be produced under the initial order as clarified herein, except those documents identified on Proctor's privilege log. So that's October 24th, which is this week, okay? And I think they just had a hearing today. I think that's the hearing we're going to watch together. I think it was from today. The Commonwealth proffers that it has received Proctor's cell phone, that an extraction has occurred, that the phone was returned to Proctor, and that Proctor's counsel provided a document entitled privilege log. So I don't know why they said if any above. Oh, that was from, okay, my bad. That was from the August 13th order. That makes sense. The phone was returned to Proctor. Proctor's counsel did the privilege log on the court order due date of September 26th. The extraction has yielded hundreds of thousands of items, some of which date back as far as 2013. The volume of items was unexpectedly larger than the representations of Proctor's counsel regarding the cell phone. Let's go down to the footnote. Proctor's counsel on July 25th and August 12th filed a motion and amended motion for clarification, which noted that Proctor changed phones in February of 24, did not preserve his old phone, and after activating his new phone in February of 24, used an auto delete feature, deleting the contents of his phone every 30 days. I wonder where he learned that. Counsel proffered, this is Proctor's counsel, therefore, regardless of the timeframes of the court's order to be clarified, it is unlikely that Mr. Proctor has any relevant information in his possession concerning this case. Almost a little like, you're not going to find anything in there. He got a new cell phone in February of 2024. All that stuff is old. You're not going to get any of that stuff. And by the way, on his new phone, you're only going to get the last 30 days. Not how it works. Joanne, Peter, who decides if it's privileged? Well, first, Proctor's lawyer. Second, the prosecutor can have a conversation if they want, if they think, listen, that's not really privileged, you need to turn it over. Third, if the defense reads something they feel like they have a legitimate argument against, and we're going to kind of see a little bit of a precursor to that in the hearing that we watched together. But if the defense counsel does not agree with the privilege log, they file their objections, they go and argue to the court, and then the court eventually will look at the privileged communications and make a decision as to whether or not it's privileged. So eventually, at first, the first bar is Proctor's lawyer, then the DA, then the defense, but ultimately it's going to be with the judge if the defense thinks something is not privileged that they're calling privileged. So eventually it would get to the judge. Gina, thank you, Peter, for always keeping us up to date. Happy belated birthday. Thank you so much, Gina. Okay, let's go back up now. Review of the extraction is underway, and the Commonwealth has identified materials that it reasonably believes to be discoverable under the Massachusetts rule in the King matter, and in other cases where Proctor is a witness. So it doesn't seem like Walshe is going to have any discoverable material. At least the prosecutors don't think so. But the King matter will, and other cases. And they cite a case that says disclosure of exculpatory information arising from unrelated grand jury proceedings, part of the prosecutor's official duties, and may be disclosed without order of the court unless the prosecutor seeks a protective order limiting disclosure. So they're basically telling the judge, we've done a lot of work. We've got the phone, we've extracted it, we've got the privilege log, we've given it back to Proctor, and we started to go through it, and we've started to turn over documents we believe to be exculpatory or discoverable. But we need more time. Additionally, they're saying there might be some stuff on here that we could limit with a protective order, but we're not at this point. In addition, where appropriate, and consistent with the Commonwealth's obligations, the Commonwealth will produce pertinent information to individual law enforcement agencies. So we're going to get to this sentence here, but before we do, earlier, the prosecutor, again, not a defense attorney, but the prosecutor said, hey, Proctor's lawyer said there wasn't going to be that much here, and we have hundreds of thousands of documents and text message. So he undersold this. And so while we thought we could get it done by a certain time, there's no way we can get it done by this time. And judges usually see that as reasonable. Even defense attorneys would see that as reasonable and good. They're like, good, I'm glad you got hundreds of thousands of documents because we want them. In accordance with the court's June 17, 25 order in King, the Commonwealth will move for a protective order prior to release of the materials to counsel in this case. So they are going to move for a protective order on certain documents. They're not going to move for a protective order in other documents. The Commonwealth will also produce the privilege log to counsel in this case upon authorization by the court. But the Commonwealth will produce pertinent information to individual law enforcement agencies. Why would they need to do that? Why would they need to do that? So somebody asked, can other cops get implicated / fired if they replied / said the same types of things back to Proctor? So I think you might be referencing some of the tweets we're going to read later from a bunch of people involved in all of this and a bunch of people that have been reporting on it, a bunch of people that have been right and broken stories. And we take everything with a grain of salt until we see it in a court document or in a hearing. That's why we're starting with the court document and the hearing, and then we'll get to the tweets at the end. But if they're producing information to other law enforcement agencies, it can be for a number of reasons, just to make sure they understand what Proctor said. If there are people that work in other law enforcement agencies that were on these chains, they could say, do what you will with this information. Or it could be, heads up, you've got a cop in your agency that these defense attorneys are going to want to talk to. And he might be on the Brady list or she might be on the Brady list. And other defense attorneys are going to want to discover what's on their cell phone because there's damning information that could be very, very bad for them. So you have to be very careful about who else is involved. And we're going to talk more about this again when we get to some of the tweets later. The Commonwealth further proffers that it reasonably believes it will be able to and is making efforts to that end to produce information deemed discoverable from the text / chats and video / audio files from the extraction of Proctor's personal cell phone on October 24, 2025. What if he used like voice memos and you actually get to hear his voice say some of this stuff? However, the Commonwealth is requesting additional time to comply with the court order in King and other cases to review other files on the extraction from Proctor's cell phone, including emails and photographs. The Commonwealth anticipates continuing the review and providing these materials to the defense in this case as soon as practicable, but before October 24th. And again, to me, it feels reasonable because the additional information than what Proctor said would be on it. That's number one. Number two, they have some deadlines coming up, and we're going to talk about that when we listen to the hearing, that this seemingly would still be okay with that. And that's the end of the motion or the notice. Okay. Now we're going to get to the hearing. And this is a hearing about discovery, about Proctor's cell phone, about the actually, before we get to the hearing, sorry, I jumped the gun on the hearing. We are going to look at one tweet. Is this the one we want? Yeah, this is the one we want. So that notice was filed on October 16th, my birthday. That notice we just read was filed on October 16th. Okay. And then on October 18th, Proctor files this: Withdrawal of Civil Service Commission appeal. This notice confirms that withdrawal of my appeal in the above referenced matter. I exercise my right to sign this form of my own free will, signed Michael Proctor. I don't see a lawyer on this. I've heard rumblings his lawyer is gone. I don't know whether that's true or not. But Michael Proctor, just 2 days after this notice, files a withdrawal of his appeal. So he withdraws the appeal of his termination, meaning he was trying to fight to get his job back. He was saying it was totally unfair what happened to him. He was saying, they treated other cops differently from me. And look at this, we're not done fighting yet. He went out on his media tour. He and his family members did interviews, but now he's withdrawing it. And I don't handle these types of cases with, unions and things like that. I don't do a lot of employment law either. I have a little bit in the past, but a lot of times when we file cases like this, or I shouldn't say we, because it's never happened to us before, but when civil cases are filed and they're found to be frivolous, or somebody withdraws or drops their case, because now I believe the next step of what is going to happen in this case is it is going to be dismissed. The commission will dismiss the case. And in a lot of civil cases, when you file something and later you withdraw or later you dismiss it, you can be basically fined. You can pay attorney's fees. You can pay costs. You can be sanctioned. All sorts of things can happen that you shouldn't file frivolous lawsuits. If you knew or should have known that this is how it was going to go, or if you said something that maybe wasn't true. And sometimes this happens to lawyers where a client will swear and say, wait till you see this document. I have proof of this. I have proof of that. And then later on in the case, you get information to say, that's not actually correct. And then you have to dismiss the case. And that opens you up to potential attorney's fees, to potential costs, potential sanctions. And that's really problematic. I don't know if that applies here when we're dealing with this type of appeal in an employment case for your termination, for a wrongful termination. But if the government has had to spend money on attorney's fees and the taxpayers are having to spend to fight your appeal, I think the taxpayers would like to get that money back. I don't know if there's a mechanism for it, but Ted Daniel found the timing interesting as well. And then he also has a tweet about the docket. Where is that? Take a look at this one. Commonwealth's notice of discoverable information from former MSP trooper's personal phone. So this is their filing of a notice saying, here we have some discoverable information from Proctor's phone on October 17th. And that withdrawal we just looked at was October 18th. Anybody else find that timing interesting? So did the lawyer really not know? Very possible. Very possible the lawyer didn't understand how it works or didn't know what they were going to be. We don't always know what they're going to get, right? I've had cases where I thought they were going to get more on a cell phone extraction. I've had cases where I thought they were going to get less. So we don't always know exactly what they're going to get. And there is very possible that Proctor's like, there's nothing else on there. I've had clients say stuff like that to me before, right? Not quite to this level where the whole case went away, but clients have for sure told me, this isn't that, this doesn't exist, or this does exist. And they just end up being dead wrong about it. And we either have to deal with it by settling the case, dismissing the case, figuring out the right, honest, and fair way to deal with something. But it is possible the lawyer really didn't know. Can the release to other law enforcement agencies be for investigating possible criminal activity? It could. I don't know that they would release it for that specific. I think they could investigate that internally with their own investigative team. But I don't know. Joe Jackson, lawyer, would you represent Proctor for a big fee? No, I'd pass on that. I also don't handle this type of work, so it wouldn't really work. Thought you were describing the prosecution in the YSL trial there in a hypothetical. LOL. I'll double your LOL, Chrissy. Charlie, how you doing, man? Thank you for gifting 5 lawyer memberships. Hope you're doing well, buddy. All right. So now we're going to get to this hearing. Okay. It's only about 10 minutes long, but let's take a listen to just how this is going. And you have to think about this. This is Michael Proctor, who's probably investigated and worked on thousands of cases. Okay. He was a trooper, a detective-ish, a supervisor. He was lead investigator in homicide cases. Like, he was a big deal. He was a big deal. He was a trusted guy. Was it Buchanan that said anything Michael Proctor put in his report, I will trust it as gospel or trust it as the Bible, something like that? He would just agree with it. That's who this guy was. And when you look behind the curtain, think about all the damage that has now been done by Michael Proctor. How many cases he's touched, how much fruit has been poisoned by his tree, how many tax dollars have been wasted literally on motions and hearings and appeals and trials because of Michael Proctor. It's not good. It's not good. Let's take a listen to the hearing.
So the entire universe, what the Commonwealth received from the feds or the federal court in connection with the Reed case is now going to be turned over.
No.
The judge is like, okay, so everything that all the federal documents that was turned over in the Reed case, now you're going to turn it over here. Prosecutor's like, no. Judge is like, that seemed reasonable. What happened there? MCKT, thanks for gifting 5 Lawyer You Know memberships.
Well, so that's my question.
Okay, I'm sorry, I didn't understand your question. I think, are you referring to the mention of TUI materials?
I am.
Okay, that was what was produced to the parties in Reed.
Okay.
So that is referred to as TUI materials for the purposes of what was produced to both the Commonwealth and the defense in Reed.
Right.
So this is a subset of those materials.
And the question is whether the obligation on the Commonwealth to review materials beyond what is contained in the order from Judge Casper is separately determined by the U.S. Attorney's Office regarding TUI materials. That is to say, the universe of confidential materials that we've been talking about for months.
Yes.
Okay. Is it all now going to be able to be reviewed by the Commonwealth and turned over to Defense Counsel, or only some subset covered by this order by Judge Casper?
We've already reviewed all the materials, and we had done that prior to the last court date before then.
Right.
We are only permitted to provide to Defense Counsel certain materials. These are the only materials that we sought permission after our review to provide.
We are only permitted to turn over certain materials. These are the materials we sought permission to turn over. Interesting language there, right? So did you purposely not seek permission for certain documents? Why?
That is to say, the other materials, we did not believe met our obligations under Rule 14.
Exactly. So they make it seem to the judge like they're only permitted to turn over certain documents. But in reality, it's like saying, Mom, can I have $5? And then say I was only permitted to have to spend $5. It's like you could have asked for $10. You don't know what they were going to say. But they looked at it. They felt like it wasn't discoverable, so they didn't ask permission to turn it over, which may be fine. And they've lost the benefit of the doubt. This DA's office here and these law enforcement agents, they've lost the benefit of the doubt. And the defense attorneys are going to talk about it as well. Hopefully they can build back up some trust with everyone in their county. But we're not there yet, right? We're not there yet.
So you reviewed all the confidential information, and the only materials that you felt needed to be turned over
that you felt needed to be turned over?
were the 2 categories of information contained in Judge Casper's order. All the rest, you did not seek authorization, either through the U.S. Attorney's Office pursuant to TUI or from Judge Casper to turn over.
That is correct.
Okay.
And the judge picked up on it too. He's like, so you looked at it, you turned over what you felt you could turn over, but you didn't ask for everything.
All right. And okay, I'll hear from the parties, the defense counsel, if they wish to address the court.
So I guess I'll start, Attorney Krosky, on behalf of Mr. De Los Santos. My understanding of the order was that under the umbrella of grand jury, we are going to receive these materials, which would include all of the grand jury from the federal court, including any and all exhibits related to Trooper Proctor. It is my understanding, though, that there
may have been more than one exhibit, so
Right.
like you only get one exhibit.
are materials outside of what actually was presented in federal court that we are also going to have access to, and that would be information from the cloud and the personal cell phone of Trooper Proctor, if I'm understanding that correctly.
So I want to make sure that I'm answering the question that's being asked.
By the way, when you ever hear something like that from a lawyer, you should listen closely. And I'm not saying I don't do it, because I would do the same thing. You're like, you're a lawyer. I want to make sure I'm answering your question. She's like, I'm not going to give you more than you asked for or less, but it's also like.
But separate from the motions regarding what was produced to both the defense and the Commonwealth pursuant to the 2A request. In King and Johnson et al., Judge Doolin had issued an order for Trooper Proctor's personal cell phone, the device, not the cloud, the device. And you modified that order. And we have been in the process of executing that.
And Judge, you opened Pandora's box, Proctora's box. That's what you've opened, okay? Because now there's hundreds of thousands of documents and information we have to go through dating back to 2013. And guess what? If it's not relevant in 2014, then it doesn't matter. 2013 doesn't matter. But if it is, then it is.
Order. And that is an entirely separate process from this.
Jameis said, if we're going to do it, we're going to do it big then. Right? That's what we're doing here with Michael Proctor's cell phone.
Right.
Right, that's what I was saying. I just wanted to be clear on the record that this is not on these cases and these defendants. This is not the end of the issue as it relates to discovery related to Trooper Proctor.
Right, but I want to be clear about what this does and doesn't do, right? The Commonwealth has done its review on all the confidential information that was obtained from the federal court, has made a determination that what needs to be produced is certain things. And as I understand it, the only things that are authorized to be turned over by Judge Casper are those things that the Commonwealth has already predetermined are the things that need to be turned over to defense counsel in this case, because
it's like such a circular discussion, right? It's like, as I understand it, the only thing that they're allowed to turn over is what they specifically designated that they want to turn over. It's like, but you can't use those words like allowed or authorized or able to when you're the one making the rules and asking for it, right? Music to My Soul said, I thought this hearing today was about the federal investigation materials, not the separate Proctor phone extraction you were discussing. It's a combination, right? It's a combination. I think they're going to mention the Proctor text, but there are some Proctor texts in the TUI information. And we don't know. I don't know if we've seen all the Proctor text that was in the federal investigation that was turned over to Karen Reed. But this is definitely more than just the Proctor texts, right? We're talking about multiple things here at once and multiple cases that these are going to touch. I'll just hazard a guess. Everybody involved here that's trying to get the federal documents from Karen Reed's case is also going to try to fight for the Proctor text and want to know what's going to be discoverable there. So it's multiple buckets we're talking about here. But Proctor's texts can be in multiple buckets as well. Proctor is the gift that keeps on giving. So much going on with him. Thanks for covering this. Peter, hey, when you guys have questions, you sign the bat signal out there. I come calling. I'm not the what is it? I'm not the hero Gotham wants. I'm the hero Gotham needs. Cindy, thank you for gifting 5 lawyer memberships. Kyle said lawyer withdrawal docketed in your inbox. Is that the actual motion or the docket? If it's the docket, that's awesome. I appreciate that. If it's the motion, I'd love to look at it. I don't think I'm going to have time tonight to look at that motion. Okay. Let's keep listening.
constitutes exculpatory evidence. But they have reviewed other things
Yes.
and made a determination that those other things do not have to be turned over, are not exculpatory in any manner in which exculpatory has been construed. And so it seems like the Commonwealth has discharged its obligation, has been authorized to discharge its obligation to review this information, the confidential information obtained from the feds, and has gotten the authorization to turn over the stuff they think needs to be turned over.
May I add two things?
Sure.
We also, because we want to be clear, as clear as we can be and as clear as the federal government will allow us to be, we sought permission to have the index, which I think is something that was discussed in hearings previously. So we also will have the index, which gives some idea of materials that we did not seek authorization to provide and do not have authorization.
So this is important, okay? They are also going to do an index. They're going to do an index of the information that they don't provide. And this is important. I hope they do the same thing for Proctor's texts. But what that is document number 1333 is a letter between two people, and it's not discoverable, it's not exculpatory, whatever it may be. So that if there is an index that looks fishy, or there's something on there that the defense looks at and says, no, we think we should get this, the judge will do an in-camera review and make a decision as to whether or not it's discoverable and whether or not the defense should get it. Now, the problem with that is still that so much of this is the state's doing, or the Commonwealth's doing. And they're the ones that are going to pick the title of the index, right? And we've seen how that's been problematic in the past, where you might title something that's innocuous or doesn't seem like it's really that important. It just seems like some run-of-the-mill motion, when in reality, it is very important, and it's not what you titled it as, and sometimes you never get to it. Yeah, privilege log has to cite a specific privilege. So a privilege log has to say, this is the attorney-client privilege, or whatever it may be. This is even more vague, as just an index of documents and just saying it's not discoverable. So that can create issues, but an index is better than no index. Thank you, Azam, for gifting 5 Lawyer memberships. It was awesome. Thank you so much. Matthew said, I work as an indexer, so I heard index today and my ears perked up. It's fun. Never thought you'd probably hear that in one of these cases, right?
Provide and are not providing. And then
And that's the index of other materials.
correct.
Okay? And that will, between the stuff that is authorized to be produced and will be produced, subject to a protective order, and the index, the defense will know all of the stuff that you reviewed.
And in addition,
Is that right?
That's correct. That's the
Okay.
intention, is so that there's not a big mystery about what the other materials were. And in addition, and why those, as outlined in the U.S. Attorney's Office letter, why those other items are not Rule 14 material in these cases.
I'm sorry, the index indicates why they are not Rule 14?
It provides, the index itself doesn't provide that, but reading the index, I think, provides some information about why they're not Rule 14 material.
Okay?
And then finally, the order now contemplates, or orders, a return to destroy date of the other materials of October 31st.
I do have some concerns, obviously, in thinking about a reservation of rights on behalf.
Because now they're also talking about destroying the materials. So it's like, hey, we're going to put these on an index. We're not going to turn them over. We don't think they're discoverable. And they're going to get destroyed here pretty soon too. And nobody likes to hear that, right? It's like they're going to get what? Destroyed. So even if later we want to come back and be like, Judge, we think you should look at these, the judge is not going to be able to look at those because why? Those are going to have been destroyed. That's a problem, right? That's a problem. Lisa, thank you for gifting 10 Lawyer memberships. Tons of members coming in tonight.
The defendants, because we're in this unique position here where the government is really the arbiter of what is or what is not Rule 14 exculpatory information. My concern is once we start getting into the actual discovery, it might become obvious to us that other information is out there that is not discovery. It's a very difficult thing from the position of a prosecutor to make a determination, not knowing the defendants and the defendant's theory of the case, what is or is not exculpatory. So I am concerned with these, quote, other materials being destroyed on October 31st. And I think there should be something put in place where we can at least have those documents set aside, not subject yet to any type of disclosure, but set aside for a potential future review.
So, Your Honor,
seems fair with all of the garbage that goes on in this case. Somebody asked why destroy them. They don't just want to keep documents endlessly. You have to pay to store them. You want to get rid of things when you can. But it's like justice first, right? Justice for all and justice first. That's first and foremost. Come on. Come on. Like, let's just hold our horses here. At least until, like, can't we just hold it until this trial is over, or the trials that these documents might affect is over? Come on. Seems reasonable to me.
This return or destroy provision, and I just want to make it clear that it is the intention of the district attorney's office to comply with the federal court order. We will be returning a set of documents and destroying all extra documents. So the defendants have had the ability to make TUI requests, to seek to intervene, and have not. We are confident that we have met our Rule 14 obligations, and I would tell the court, and the other assistant district attorneys who participated would tell the court if they were not confident. And again, I think the index will be helpful, and I'm able to provide that index today.
Okay, I think what I will do is, in an abundance of caution, and against my better judgment, because I really don't want to have another hearing on this, but I will schedule a time to see anybody who wants to be heard on the issue of the other list sometime next week, after you folks have seen it and have had a week with it, to consider whether you think there's anything that you need to bring to the prosecutor's attention about the things that might be on that other list. You obviously don't have the other list, so you shoot blind right now, but you'll have it today. And you'll be able to come to some sort of conclusion as to whether you think, given the information on that list, you have some reason to believe that it would contain exculpatory information.
So again, that's how it should be done. That's exactly how the process goes. The problem is you have to rely so much, and you have to trust prosecutors to make an appropriate index, make appropriate titles, list things the appropriate way, not leave any documents out that are going to get destroyed. Now, the other side of this is true too. And I've literally had cases thrown out in federal court for documents and items that have been destroyed that later were very obviously discoverable, shouldn't have been destroyed, was going to be evidence at trial, and got destroyed. So the prosecutor needs to be careful too, because I mean, at this point, it's like just so much going on in my head to where they're willing to risk it because of how bad all of this is, right? And with all the Proctor stuff going on. But in normal circumstances, if you put in an index or a privilege log that this shouldn't be turned over, and then later it's like, obviously this should have been turned over and now it's been destroyed, who does that count against? The prosecutor. Now, it's easier said than done to prove that, right? In our worlds, in our mind, we can be like, oh yeah, that's not fair. You know, that shouldn't have been turned over, or this should have been turned over. It's like, it's so hard to get to the point where you even know that a document or an item exists that should have been turned over. It's not just like we all know the same things all the time. Prosecutors know so much more than defense attorneys know. So it's so hard to really get to the bottom of so much of this. Joanne said later, it makes me sick to live in Massachusetts right now. There are good police out there. Can they convict Proctor for anything? We'll see, right? I mean, a lot of this is just kind of civil stuff going on right now. Get rid of the whole county at this point, Michelle said. Faith said, after months of watching, I finally caught a live. Faith, welcome. We're pumped you're here with us. We're almost done with this hearing, and then we're going to read some tweets to finish off the video.
Based on the chronologies in your case or whatever else it is. Sure. Okay.
For the parties, I am back here on October 30th.
Okay, so they're going to come back on October 30th, and they're going to deal with this some more. Okay, so we're not done with this yet. 10 days till we come back and have another hearing on this. I assume the defense is going to look through the documents that have been turned over. I assume the defense is going to look through the index. I assume that we're going to have a little bit more information before the next hearing. And I hope that we have more information before the next hearing, because from our perspective, there's so much out there that we don't know. And speaking of things that we don't know what's in Michael Proctor's text messages. But there have been some reports trickling out. Idiot Win said, MP Michael Proctor has been an MSP trooper for 10 plus years. What happens when potentially exculpatory information in cases that have already ended in convictions? Again, that's why it's so hard to go back once you've been convicted. Appeals are for losers. All this stuff's for losers because you lose at trial first before you even get to this point. And that's the worst case scenario. is there are wrongfully convicted people in there because of something Michael Proctor did. That sucks. And they can fight it. They can try to search for it. They can try to appeal because of it. But in reality, it's very, very difficult. So we're going to look at 6 tweets here. We're going to have some comments on them, but mostly we're just going to read a tweet. And you guys can discuss, and we can all discuss together what we think it means if we read between the lines. First tweet, Aiden Carney, aka Turtle Boy, reporter on this case, has been intimately involved, many would say, talking to lots of different people with lots of different sources. Michael Proctor's attorney, Daniel Moynihan, dropped his appeal of Michael Proctor's termination yesterday. This comes 2 days after a new filing in the Brian Walshe case, in which 13 years of deleted text messages were discovered in his iCloud. Nothing is new yet. The motion states that the data is discoverable for Miles King, not Walshe. Miles King is Black. According to sources who are quote-unquote friends from Proctor's inner circle, Proctor has admitted that the text messages are racist and are directed at defendants and coworkers. Proctor is reportedly not doing very well with this, and neither is his wife, Elizabeth. So, what is in these texts? Because if Proctor is being disparaging and racist and horrible with these defendants, and you can see how it lines up to be biased against the defendant. If I had something like this where a cop was very obviously showing bias against my defendant for what they look like, or what their race, religion, creed, national origin is, I'd have a problem for that. With that, I'd have a problem with that, a big one. All right, let's go to the next tweet. From Turtle Boy again. Just a reminder, Michael Proctor did not send racist text messages to himself. Someone else received them and was okay with it. So I don't know if they were okay with it, right? I'll just tell you also from these Turtle Boy tweets, it certainly sounds like he has seen them, right? And we're going to read one more that will give us that indication as well. But somebody else received them. We have information that they're notifying other agencies. We know Yuri Buchanan was questioned about a lot of these. He acknowledged some of Turtle Boy or some of Proctor's other text messages. Major issues depending on who he was sending these to. Are other cops that are not Michael Proctor still saying, yeah, that's right, confirming, racist terms. Let's get this, some derogatory term or some hateful term toward any defendant? Are they confirming this? Are they going in on it with him? Because that's going to be a problem, and it's not just going to be Michael Proctor that we're looking at. It's not just going to be Michael Proctor that's being grilled on the stand. All right. So somebody said I sure hope DMA News is watching because Aiden Carney just published an article where he claims to know the content of protected federal materials in regard to the content of Michael Proctor's texts. The question becomes who gave it to him. So just again, somebody asked this earlier. There's multiple buckets. There are certain things that are federally protected, certain things that might not be federally protected that are in Michael Proctor's phones. So we really don't know what is and what is not. That's kind of the point of things being under sealed. And we don't really know what is protected and what's not and what's located in what bucket, right? And Aiden Carney says, oh, good, Big Red, I guess he's talking to her, finally admits that my reporting is accurate. Spoiler alert for Twitter law school students. Proctor text messages are not under federal protective order. And when you find out who from Proctor's inner circle leaked this information to me, you're going to be shocked. Keep talking, Lizzie. So when you're looking at it this way, Aiden Carney doesn't seem nervous about this, right? Seems like he's saying he has the goods, that he's seen the text messages, that there's some conversation about has he seen them? Who else is on the text messages? What is the context of the text messages? I find it all to be interesting. Then some corroboration to some of what Turtle Boy is saying from none other than Mr. Mark Betterow. The key questions are this: to whom did Proctor share his racist and homophobic biases about defendants? And what, if anything, did these other people do about it? Did they join in? In Karen's case, we know it was Yuri Buchanan and others he shared info with. What about these newly discovered messages? So Mark Betterow seems to at least confirm some of it, adds maybe the homophobic came from somewhere else. I don't know that Mark initiated this, but I'm saying he is sharing this as well. And you've got to understand how important this is. Regardless of what you think about any person who you agree with or disagree with, if there's a cop or a prosecutor with the type of power they have that goes after somebody because of something they believe or think or how they look and forces their way into arresting them, prosecuting them, throwing them in prison, that stuff happens, okay? We're not so far removed from it being rampant. That stuff still happens today. And we have to stop it and we have to fight it when it comes to these prejudices entering into our judicial system, which is why we're allowed to ask and strike any juror that has this bias. It's no different from law enforcement. If they have these biases, they cannot be on these cases. And if they do, and they did this type of work, the jury deserves to know about the biases of these law enforcement officers. Here's another Betterow tweet. The impact the disgraced Michael Proctor has had and will have on serious criminal cases is immeasurable. Wishing death on defendants, mocking medical conditions, disgusting racist statements about defendants and colleagues, homophobic comments, and very possibly planting evidence on and concealing evidence. He is a one-man wrecking crew and the poster child of the rotten system in Norfolk County. It's not good. Make sure everybody hits that like button. We've got one more tweet to read, and I think you're going to want to hear it. At what point does his behavior become criminal? Who would be responsible for prosecuting him? Well, Norfolk County DA's office should be disqualified at this point. But they'd have to actually prove he planted evidence or concealed evidence. Saying things in text messages, as horrible as that is, it can make you lose your job. It should absolutely be held against him if he's ever a witness anywhere for his credibility. But it would take more than that to get him for criminal charges. He would actually have to force crimes, plant evidence, wrongfully arrest people, knowingly wrongfully arrest people, right? We'd have to have more. Selective memory failure. Are the federal documents at issue from Proctor's personal or work phone? Do we know? Couldn't that be an issue? I don't know the answer to that. I don't know what's in the federal documents that were produced to Karen Reed or that the prosecutor has that they have not produced all of. I don't want to say what's in what bucket because, again, I haven't seen the differentiators and the different sets of buckets where they're putting these documents. Somebody as Lizzie is talking to leaking it. I don't know who Lizzie is. Is that Elizabeth Proctor, Proctor's wife? I don't know who Lizzie is. I'm not up on all the nicknames everybody has for everybody. It couldn't have happened to a better guy. We're going to party like it's 1983. 1983. I think Kelly's referencing a civil rights action that's coming. Kelsey just told me that's Proctor's wife. Okay. Antonio, Proctor is a racist. I'm shocked by this revelation. Anyways, I have a crim law and torts reading to do. Thanks for the study break, Peter. Antonio, enjoy it. I love torts was one of my favorite classes in law school. And so was civil procedure, which is kind of crazy. Criminal procedure was probably my favorite class. Loved criminal procedure. And I feel like that's the most of what we talk about on YouTube, which is kind of funny. You should have Melanie Little on your pod. I have had her on one time. We'll have her on again at some point. Yes, everybody's telling me that's Proctor's wife. Okay, let's take a look at this last tweet. It's from Ted Daniel, but it's really from Alan Jackson. Check out this picture of Alan Jackson. New statement from Karen Reed's attorney, Alan Jackson, on Michael Proctor withdrawing his appeal to get his job back with state police. Michael Proctor's sudden withdrawal of his appeal wasn't an act of humility. It was self-preservation. He learned investigators have recovered text messages from his private phone dating back years, and he wanted no part of what those text messages would reveal. He didn't accept accountability. it hunted him down. And as Colonel Noble has admitted, the years-long corruption is systemic. Woof. So he's withdrawing his appeal. Again, it's not going to make these text messages go away. It's not going to make them never see the light of day. But it definitely it definitely shines less of a light on them. It shines less of a light on them. It makes them less out there for everybody to see and read and hear. Yeah, everybody make sure you hit that like button if you haven't already. Aaron, Lawyer, are you a Tampa Bay Bucks fan? Looks like Evans may have just had another season-ending injury. Hope he's not on your fantasy team. He is on my fantasy teams, but also, yes, I'm a big Tampa Bay Bucks fan. No other spoilers because I'm going to go watch it. It's about to be halftime when my video is going to end. I'm going to catch up at halftime and watch the rest. Hopefully Baker brings us for a comeback. I saw they already scored once. Love Baker Mayfield, MVP. Sucks that Mike Evans is hurt again. I really hope that's not true. I hope it's just another slight setback because I love Mike Evans. Might be the best wide receiver in Bucks history. So that sucks. Okay, that's all we got, folks. And we did it in under an hour, just like old times. You guys are the best. Will you hit that like button? Will you make sure you subscribe? If you have not subscribed to our page, make sure you subscribe. Would love to have you guys on future videos. Thanks for coming to hang out tonight. Till next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, X, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast featuring new episodes every week. And if you have a case that you want to personally talk to us about in your life, if it's a personal injury case, wrongful death, catastrophic injury, car accident, truck accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.